Affirmative defense simply means that the petitioner or the plaintiff cannot prevail. No matter what they say, no matter what evidence they have, no matter what they prove, they cannot win. So for example, statute of limitations is the most common affirmative defense. So if you have a trust or will lawsuit and somebody was served with a 120-day notice, they cannot contest a trust after that 120-day time period runs. So it doesn't matter if the person wanting to contest the trust has the greatest case in the world. They may have the best evidence, they may have the best experts, they may have the world's best case. But if they wait beyond the 120 days to file a lawsuit, they simply cannot prevail because they violated the statute of limitations. That's a clear affirmative defense. The defendant or the respondent in that case will win regardless of how good the evidence is against them. So how do you use an affirmative defense? Well, if you don't state your affirmative defenses up front when you file your answer or your objection, then you waive them. You waive the right to use them later on in the process, and you waive the right to use most of them at the time of trial. So that means when you're being sued, you have to sit down and really give some serious consideration to what defenses apply to you, to what defenses you want to raise, so that you can use them later on down the line when the time comes. Some of the affirmative defenses that you see quite a bit, statute of limitations is number one. Failure to state a claim is a common one. That simply means that somebody did not plead facts that support an element of whatever their legal claim is. And then there's equitable claims, such as estoppel, laches, unclean hands. These are equitable doctrines that the court can use to prevent a petitioner from winning their case if they feel like it's fair to do so under the circumstances. For example, the doctrine of laches simply means that somebody sat on their rights too long. They waited too long to file a suit, and therefore the court's not going to let them prevail. There's no set time frame for laches. It's kind of this loose concept that the court can use. It all depends on the facts and circumstances of your case, whether or not the court's going to apply laches or not. The bottom line is that affirmative defenses strengthen your case. It allows you to prevail on a lawsuit if you have the evidence to back up one of your affirmative defenses.